start over. Monthly, we have an agent-led training. And this month and next month, actually, Wendy's going to be one of the agents that's training us. I really enjoy when we have agent-led trainings from people within our team, because it really gives everyone a chance to like share their value and their knowledge and also loop in other people. And I just, something about like doing that within the team, I think is really valuable and really special. And Wendy's going to be talking to us today about trust and probate sales, which you might think maybe you don't run into that often, or probate sales, how often does that really happen? Is that really relevant? And the answer is yes, absolutely. Because when, not if, when you run into that, when that happens to you, you need to know and be equipped with the knowledge of what to do, because your clients are depending on you and leaning on you as the industry professional to be able to guide them through that in the best way possible. And so, Wendy, I'm really excited for you to train us on this. I'm going to let you explain a little bit more of trust and probate sales and what that actually is.
Sure.
And feel free to screen share if you have a presentation. If not, that's totally fine. But yeah, thank you everyone for joining. Thank you, Wendy, for being kind enough to host this meeting. And I'm going to turn it over to you.
Very good. Thank you. And good morning, everybody. I just wanted to remind you that, first of all, this is just an internal training for here. Can everybody see my screen? For some reason, I can't see you now.
Not yet.
Okay. Let me go back. Say share screen. So. How about now?
Not yet. When you're doing the screen share option, is it asking you to share like a certain window or entire screen, or make sure you have the right permissions?
Select a window.
Okay.
I just want to make sure I bring up the right version.
There we go. I see a screen share. I see it. It looks like it's the Zoom sign up link, but I see a PowerPoint down at the bottom. I saw a window pop up for PowerPoint.
Okay. All right. So let me go back there.
All
right. Good. Okay. I'm going to go to the top here. So first of all, thanks everybody for being here on this warmish day. Yeah, so probate and trust sales, they are two different things, but I just want to remind everybody that this is an internal training. This is not the certification that I went through, and I am leveraging from that training. It was given by this gentleman named Paul Horn, who is a probate attorney and a CPA, so very reliable. And it took many, many hours. We're not going to do many hours now. We're just going to do this in less than an hour. And in my certification, there was a test at the end. There will be no test, I promise. But this is more your education, and it's actually said opportunity for us to kind of learn from each other. So, and just to kind of get to why it's even important to know this Ashley also alluded to this. Attorneys who do manage the probate process really want to work with real estate agents who know what they're doing and understand the probate process. So there are certain forms to be used. There are certain processes that we need to follow. They want to know that you know how to carry out a smooth sale and ultimately get the best return on the sale of that property. And so probate is actually a lucrative avenue for real estate agents. If we work with a title company, they can usually pull up notices of death or cases where probate has been opened and get a list of those, and we can start marketing to them. So there are opportunities there. So I just want to do that little preamble, go down. So how do we tell, I think I went too far. Yeah, so what is a probate? So a probate is basically a court sanctioned process. It happens when someone dies, this is called the decedent, and any property that might be left by that decedent eventually will get transferred to the living heirs, but there are certain things that need to happen first. In the normal transactions that we do, we have the owner sign the listing agreement and so on and so forth. Well, in this case, it's the listing agreement is going to be signed by whoever is authorized for this transfer, and obviously not the person who passed away. And a probate occurs if the decedent did not have a trust. And this is kind of important. Even if they have a will, when someone dies without a trust, the transfer of their property must be done through the probate process, and it can be lengthy, up to a year, which is no fun to have to wait. What will happen is that someone will have to hire an attorney, someone in the family, one of the heirs, have to hire an attorney who will prepare the paperwork to ask a court or a judge to appoint a personal representative. And that personal representative is going to probably, it could be the spouse of the person who has passed on, it could be any of the children, but it can also be an attorney. So but it is a long process that they have to go through. And the person that does get appointed as the representative has a lot of responsibility for reporting back through the other heirs of where things are at, always being available to answer questions from the attorney who is appointed to shepherd this probate through the court system. After the sale of any real estate and personal property, and creditors. So the whole point of once someone has passed on is that there is an estate, might be small, might be large, but and there is a small cap, by the way. If an estate is not valued for more than, I think, $180,000, then it doesn't go through probate. But that's pretty small percentage of the kind of things that we're going to be talking about today. So after the property has been sold and after creditors have been paid and any personal property has been disposed of, then the proceeds are distributed. And that takes about a year. The good news for us realtors is that we don't have to wait a year. So I'm going to go to the next slide. First of all, let's talk about how do we tell if a property is in a trust. So I just copied this from the property profiles that we all access, and you'll see that the current owner in this case are two individuals, and I don't know, it's pretty tiny, maybe you can't read it. It says owner right vesting, and this just says as joint tenants. A lot of people hold property as joint tenants. This owner is vested as a family trust. That's what those little tiny letters say. So that'll tell you right away, oh, we're in a trust situation. And that is much more beneficial to everybody because things move much faster and you won't have to go through probate. If you're on this side and one of these owners passes away, again, even if they have a will, that is going to have to go through probate. So bear that in mind for you, yourself, or any of your family members. And if you, not that we're supposed to be legal counselors, but just advise that if there is no trust, they might want to consider getting one just because it protects everybody, especially the heirs. All right. So that's how we tell whether or not a property is in a trust. You can do that, or you can ask the title company to pull up the most recent grant deed, and it will tell you the how the property is held. If it's a family um, trust, or if it's joint tenants or tenants in common, things like that. But in this case, we're talking about family trust, or just a trust in period. Doesn't have to be a family trust. Every trust has a name and a date that it is effective. And once that is in place, that travels with any revision. All right, so let's go through the process. And this is the probate process. So and in this case, we know that there is no trust. So someone in the family will have to hire an attorney to file a petition for probate. And so there's usually a lot of discussion amongst the family members. Could be the surviving spouse, it could be, children, but one person gets appointed, and hopefully everybody's in agreement with who that person is. And then the attorney will file papers asking a judge to appoint a personal representative in this probate process. So that's the confirmation of the personal representative. Once that occurs, then the court clerk orders a couple of different papers. First of all, the probate order will have been ordered, but there are what they call letters. It'll only be one of these, but there's something called letters of testamentary. That means there was a will. Letters of administration, meaning there was no will. And then there's letters of administration with a will, but the executor is not available. So they could be unavailable because, I don't know, maybe they passed away themselves, or maybe they're just in another state and they can't really act and take that responsibility. So the letters, though, are what allow us as realtors to proceed with a probate sale. And this is what escrow will ask, well, can I see your letter? And it'll be one of these letters and the order for probate. So now they know, okay, we're doing a probate sale. And so very important to get that done ahead of time. We can never chase those probate sales with these letters. They are a requirement before we can even get started. And if anybody has any questions along the way, feel free to jump in. I don't mind. Or if you want to put them in the chat, we can catch that later. But there's a lot to cover, and if this is a new topic, then it's probably going to generate some questions. And I do have a timeline that I'm going to show you in a little bit. So we're at the process. Oops, sorry, not that one. There we go. So once the court issues these letters, we can proceed. And when we do, we use our standard residential listing agreement and all of the other agency disclosures, the whole package that comes with the listing. But there's also another form called a probate advisory. And then when you get into a contract, there will be a probate agreement purchase addendum, so that everybody involved in the transaction is aware that this is a probate sale, and things may take a little bit longer than usual, but not a whole lot. That's good news. A listing for probate, once the letters are in hand, we can go on the market pretty much within about 2 months of the probate and the letters being received. So there are a couple of requirements that we have to meet. So it's a listing. It's on the MLS. It's listed as a probate sale, and we say that maybe not in the actual MLS agreement, but anytime anybody approaches you and says, "Well, we'd like to make an offer," you have to be within 90% of what is called a probate referee's appraisal. So this is another individual that the attorney will put you in touch with. They will come look at the property. They are the probate referee. It is a separate cost. I'm going to go over some costs a little bit later, but the probate referee will appraise the property, and no offers that are below 90% of what that appraisal amount comes in would be considered. Fortunately, I don't think we're running into too many of those under market situations now, but the other thing is that if an offer is made and accepted, there is a requirement for what is called a court payment. Now, it sounds like you're paying the court, but what you're actually doing is paying a down payment, but the court only requires 10%. So this is not a 80-20 type of transaction. But you do have, the buyer has to come up with 10% of the purchase price as the down payment. And this is more good faith and to show that, that they're going to be good players in this, and that they actually do have the referral. Sorry, not the referral, but the pre-approval to go ahead and go forward with this transaction. The listing agent commission is guaranteed at 3%, and for the buyer's agent, it is also guaranteed at 3%. So the court doesn't meddle with anything. They just say 3%, that's it, 3%, that's it. So we're all good. And we're kind of grateful for that, because sometimes we're struggling to keep our commissions as high as possible. And it also says that the personal representative who has been appointed has the full authority to administer the estate. So they are the ones that will sign the listing agreement. They are the ones that will accept the agreement. Now, that person will have, probably go back and consult with the other heirs just to say, we've got X number of offers at certain price, and here are some of the terms, and that would be a normal discussion. But this representative does have the full authority to accept the offer. So if and when they do accept and sign the agreement, then you're in contract. And if things go smoothly on the sale of this transaction, then the realtors involved get paid at the close of escrow. So I mentioned earlier that these probate sales can sometimes take up to a year. That's really the time period that the heirs have to endure. The real estate agents have performed and done their transaction duties early in the process. The money from that gets paid to the real estate agent, but the bigger bulk gets put into a fund that the other creditors, the other people that are owed money, the personal representative can sell personal property, and all of that gets put into a fund. And then from that, the heirs would get their distribution, however it was determined that they're going to share it. So that's the good news for us, is that we don't have to wait a year. We can get this deal done, but it's important that we help move things along timely and appropriate, using the right forms and communicating a lot, because this is usually the first time anybody's ever done anything like this. So people want to have their hand held and be assured, yep, here's the next step from a real estate standpoint. Again, we're not attorneys, and we will probably consult with the attorney along the way, but our responsibility is just for the transaction itself and doing things properly. Okay, now I'm going to jump here. I wanted to show you this timeline. So this timeline, I thought was kind of well done by Paul Horn, who conducts the NAR training for this, but it shows that the petition for probate starts, and then there's a hearing date, and that's usually, it takes about 5 or 6 weeks before this court date. And during that time, hopefully, there has been someone that has been agreed to within the family as to who will be the personal representative. And then you have to publish a notice in the newspaper that someone has passed away and the proceeds of the estate are going to be administered, and that there is a personal representative that has been identified. Then, wow, so once the court has given the approval for things to move forward, the court clerk files these letters that I referred to earlier, depending on if there was a will, no will, or maybe, excuse me, the will executor was not available. And so those are your documents that you want to hang on to: the order for probate and one of the letters that is appropriate to the condition for the estate. So then we're going to get into a real estate transaction. I'm sorry if this is really tiny, but we're going to hopefully get an agreement. We're going to, it'll be a standard purchase agreement with the probate advisory attached, and all the other forms that I discussed earlier. And then we're going to hopefully drive this to conclusion, and the escrow company will have all of the documents that they need in order to proceed. And then we close escrow. This is great because you're only within 2 months of someone passing away, you're able to execute, help the estate, the family, settle the affairs for the real estate. And in the meantime, they've probably begun the process of, I don't know, selling the boat, the car, whatever other assets there were to be sold. But the proceeds from the real estate and any personal property go into that fund, and then they notify creditors who can, you know, apply to be paid if there were any outstanding debts. It also covers taxes. So taxes are going to get paid first, creditors are going to get paid second. And this is after the close of escrow. So then you're going to have a period where there's just a lot of for the errors anyway. They're going to have to wait a long period of time, mostly because there are so many court cases for probate that you just have to kind of get in line and take a number. Does anybody have any questions about this timeline, probate process? Nope. Okay. It seems overwhelming, but actually I've done one of these before and it actually goes pretty darn smooth. So I'm going to move to the I already did 3%. Okay. So that is probate. And then there's another function called a trust sale. And I've done quite a few of these because there are a number of people that do have a trust. So a trust is basically just a fiduciary arrangement that allows a third party, meaning a trustee, to hold assets on behalf of beneficiaries. The beneficiary could be the trustee, but it could also be extended family, it could be a charitable organization, or whatever the person who owns the trust has stipulated they want to do with the proceeds from their estate. It is very beneficial to have a trust in place. I'm not going to quote an attorney fee for this, but somewhere in the range of $4,000 to $5,000 will get you a very good, solid trust. And a trust will also include a will. So that's all taken care of. Trusts are used to minimize estate taxes because things can just be transferred as opposed to having to go through a more expensive process that offers, you know, other benefits. The trust is the owner of the property, not an individual. So the individual is a successor trustee, but there will also be named someone else who's like in the event of a trust that is for an individual, they will designate a co-trustee, because if they have passed on, someone needs to be named as the successor trustee. And it's usually the spouse, or again, it could be one of the children, it could be an attorney, it could be a number of people, but it's always clearly defined as to who the co-trustee, successor trustee is. And those successor trustees have full legal authority to hire you as a listing agent, and they don't need to go through court. It all happens very quickly. You will get a copy when you take a listing if there is a trust. And it doesn't mean that somebody's passed away, it just means that their home, their real property is held in a entity called a trust. So the successor trustee is going to be able to accept any documents, sign to close escrow, accept offers, and etc. So those people are already clearly defined. There's no question about who has the authority to do this. And again, the trust will almost 100% of the time include a will, of which there sometimes is even an end of life directive there. So it makes it very clean, very smooth, no question, and it authorizes the successor trustee to move forward. So that's a trust. Show of hands, how many people have done trust sales? I'm not seeing too many. Okay. Well, like I said, when you take an offer, oh, Brittany has. When you take, when you take a listing and you go to your MLS and for the property profile, if it says it's in a trust, you're going to need that, I'm drawing a blank. You're going to need that trust certification. So that's just a portion. It's not the full trust. For example, my personal trust has like 81 pages because my husband and I have children from different families, and but there's a little section that's about 6 or 7 pages that says trust certification, and that is the authority, all the authority you need in order to take a listing or even write an offer on behalf of a trust. It's sort of an abbreviated version, and all it says basically is that this individual is authorized to get into this transaction as a trustee or a co-trustee. So certification of trust. Properties held in trust can be sold anytime after the death of an owner. So there's no waiting period because it's already been determined who the successor trustee is. And the family has been notified, hopefully, in advance that this trust is in place. So they know that this is how things are going to roll out. Properties held in a trust must use the residential listing agreement, but then which includes, all the usual attachments of agency disclosures and PRBS, et cetera, et cetera. But it's also going to include a form called a trust advisory. And that just basically puts everybody on notice in the transaction that this is a trust selling the property, not an individual. And it's just, it's a disclosure, pretty much. Just everybody knows that. And when the buyers or the sellers who are in the trust are making the transaction, they will sign as a co-trustee, or not as a co-trustee, but they will sign their name. And after that, they'll put comma trustee, because they're not selling it as an individual, they're selling it only as a trustee. And then there's the seller's advisory that needs to be signed, acknowledging the existence of a trust. And I wanted to go over the expenses of not having a trust. This is painful. This is painful. So I just took an example. For a home that's valued at $1 million, which is not unusual around here, a court ruling, excuse me, shows that the fee that the court assigns, so this is not negotiable. The court says there will be a fee applied that is 4% of the first $100,000. So that would be $4,000. There will be a 3% amount on the next $100,000, and then 2% on the remaining amount. So in this case, $800,000, for a total of $23,000 that goes to the probate attorney. That's a lot. It can also impose the equivalent amount to the personal representative, the successor trustee. Now, let's just say that trustee was a only child, or there's no other heirs. That person could elect to forego the $23,000 as compensation for acting as the co-trustee, successor trustee, sorry. But they're probably going to get the lion's share of the estate anyway. But you can see that there's a $46,000 fee for not having a trust and having to wait 1 year. So I think the moral of that story is get yourself a trust if at all possible. And not only that, but before you even begin this process, you're going to have to engage an attorney to start the whole ball of wax going. So that attorney is going to have a retainer fee. And sometimes those retainer fees could be, I mean, they're limited to what they can charge, but ultimately they're going to get that $23,000, but you're probably going to have to hire them on a retainer fee basis. And who knows what attorneys are charging these days? I mean, it could be $10,000 on top of the 46. So it could be quite extensive and not a whole lot left over in the estate once the trust has been resolved and creditors paid, et cetera, et cetera. So that is pretty much what I have. It's a very abbreviated version of many hours of the probate and trust certification that I went through, but I'd like your feedback, whether or not this was enough to kind of get you thinking, started. Anybody?
I
just
think
wanted
it
to
was a
mention-
great overall review. I loved getting all the information. I was taking notes and screenshots as we were going through it.
Good. I went through, I don't know, it must be 98 pages of the handout that we had to read and go through. There's a whole lot more behind this, but I'm trying to focus only on really what would affect us as realtors. But there's a lot of background and reporting and things like that that you have to do, and it's time consuming. But man, I'll tell you, having a trusted place certainly makes things a lot easier, and things go a lot more smoothly. It's already been decided who's the successor trustee, and that successor trustee, it's on them at that point to just, carry the rest of it through for the rest of the year. But at least the person that we have to deal with is identified, hopefully cooperative, and we're trusting us because we have the knowledge to help them get through the probate process for selling real property. We don't get involved in all the personal property, and we don't get involved with creditors, but our role is for the real estate, and we get to get that taken care of early in the game and get paid for it, which is nice. And then it's done. Anything else? Brittany, tell us about your experience with trust. Can you do that while you're driving?
Um, no, I just had it wasn't a probate sale though, so it wasn't a probate, but I just did one just dealing with the trust, and it was super smooth versus not. I do have a question. Do you recommend to your clients like putting title as like in a trust? Do you have that conversation with them at all?
I do. You know, we have a fine line to walk to not be attorneys, but I do kind of walk them through the difference between a probate and a trust, and how, you know, a lot of people think that, oh, if I put it in a trust, then it's not mine anymore. It couldn't be further from the truth. It's yours. You are the trustee of the trust. It's just that in order to take any action or sell anything, it's going to go a lot more smoothly, and it's going to be easier for anybody who might be in a position to inherit anything to get it taken care of smoothly and quickly. But yeah, I encourage people to say, you know, a trust is the ideal scenario, but as a real estate person, I can't really cross the line and say, don't sell your house unless you're in a trust.
Awesome. Yeah, no, I just was thinking like if you, well, yeah, I don't know, just that was really great information. I didn't know. Yeah, just awesome information.
Okay,
Thank you.
very good. Well, glad to hear it. So now you know everything, well, pretty much everything I know. If you want the 98-page version and you're having trouble sleeping at night, I'll be glad to share that with you. But it will not make you a certified probate and trust real estate agent. It will just, you know, inform you with more details than you probably need. Because again, a lot of it is outside of our purview. We're only dealing with the real estate transaction. All right.
Looks like Diego Velez had a question. He said, do we need to get certified in order to take on a probate transaction?
No, you don't. You just need to know how to move it through the sale process. So if you're writing up the offer and you get the probate order and you get the one of the 3 letters that will be issued by the court, that pretty much is what escrow will require before they can open an escrow. So you don't need to be certified. I did it just because I run into situations with people where I like to be able to be an informed and knowledgeable, you know, speaker and presenter, and assure them that I have been certified. But it's not a requirement. It's not a requirement. You can take a probate sale, and you'll probably work more closely with the probate attorney just to, you know, make sure that you're in lockstep with them on where they're at with regard to administering the probate. But once you have the co-trustees or the successor trustees, sorry, I keep mixing those up. Once you have the successor trustees signature and you have them shown as being appointed as the personal representative, then you're pretty much good to go. After that, it's just pretty much the same kind of execution on any transaction that we go through. It's just that there are a couple extra forms to notify all parties involved that this is a probate or this is in a trust. Yep, that's it. Anything else? Anybody have any other questions? And if you do have other questions and you think of them later, just Slack me and let me know. I will put this presentation, let's see. Where should I put this presentation, Ashley?
I think TBR team all would be good. And then This video will be up within 24 hours on YouTube, so you guys can always go back and reference it. Louis puts it in the, gosh, what channel is that? YouTube and Loom Videos Slack channel. It'll also be on our YouTube channel, which the link is pinned in Slack, and you can also find it at the top of the weekly waves. So you'll be able to go back and watch this entire presentation as well.
Excellent. Okay.
Thank you so much, Wendy.
Oh, you're so
job.
welcome. Thanks, everybody. Nice having you with me. Happy to share. I learn something new from everybody myself every time I sit in on one of these trainings. So I hope you found it to be of value as well.
For sure. All right. Have a
Okay.
great day, everyone. Thank
Yep.
you.
Thank you.